This is a really, really exciting panel. And I am absolutely delighted that we have probably the world's expert on prescription drug monitoring programs here from a legal standpoint, Nate Wessler. He's, it's amazing how many people are interested in this panel, and we're so grateful that all of you came to help. And I think everybody here knows what a prescription drug monitoring program is. Every state is supposed to have a database of all controlled substances. And what a lot of people don't realize is it's not just restricted pain medicines. It's medicines that a lot of people take. Hormones are part of it. There are also medications you might be aware of for things like attention deficit disorder. And so it's really not just pain medicines. That's one of the foci. But when these, so I'm just going to say this, so this is why Nate and I got involved, but when you take a look at all of the drugs that are scrutinized, they make the patients and the doctors that write the prescriptions feel like criminals because they're recorded, and the Drug Enforcement Agency used to get all the copies of the triplicate prescriptions and so on, and now many of them have been unfortunately opened up to law enforcement without probable cause. Is that correct? Okay, so I'm done. So this is an exciting and important panel, and is it, I can't remember the statistic exactly, isn't it that like 2/3 of Americans have their medications in a PDMP available for surveillance? 2/3, you wouldn't think of it because most of us are not on pain medicines. So there's a lot of medicine in there that might be sensitive and be exposed. So thank you.
Thanks, Deb. And good morning, everyone. Thank you. My name is Nate Wessler. I'm a staff attorney with the ACLU Speech, Privacy, and Technology Project, where I work on a range of digital privacy issues, including litigation and advocacy around making sure the protections of the Fourth Amendment apply when law enforcement wants to get access to people's sensitive digital prescription records in these monitoring program databases. So I'm pleased to be joined by a fantastic panel. And I'll just do very quick introductions because I want to jump into our discussion. So next to me is Lisa Matsubara, legal counsel with the Center for Legal Affairs at the California Medical Association. She's done significant work to strengthen the privacy protections in California's prescription drug monitoring program. Next to her is Ryan Pyle, a firefighter from the Salt Lake City area in Utah, who can speak from personal experience about the importance of preventing phishing expeditions by law enforcement officials into this highly sensitive digital database of medical records. And at the end, Mark Greenblatt, a senior national investigative correspondent with Scripps News Service, based here in DC, who last year published a very impressive nationwide investigation into the differences in privacy protections for PDMPs across the states. And he'll be talking in more detail about what he found. So let's jump right in. Lisa, can you get us started by just setting the stage, explaining what is a prescription drug monitoring program, what records are in them, who's tracked, who has access, those kind of questions?
Sure. So a prescription drug monitoring program, or a PDMP for short, are basically electronic databases. They gather information from pharmacies on controlled substances that are dispensed to patients. And those controlled substances can range from Schedule 2 through 4, or even some states collect Schedule 5 and even non-controlled substances in their PDMPs. And what that means is, Schedule 2, I think most people understand to be sort of opioids, oxycodone, hydrocodone, things like that. But when you go down to Schedule 4, Schedule 5, it actually includes a great number of drugs, including things that can identify medical conditions, anxiety, if you're having some sort of cancer treatment, HIV/AIDS, hormones for gender transition. These are kind of the sort of drug-specific therapies that will definitely result in people figuring out what kind of medical condition you have. I think at this point, all but one state, Missouri, has a operational PDMP, and different states house their PDMP in different agencies. Some of them house them in their health departments. Some of them do licensing boards or their board of pharmacy. Others have a consumer protection agency overseeing the programs. 3 states have it in the Department of Justice. California happens to be one of them. In California, it's called the Controlled Substance Utilization Review and Evaluation System, or CURES. And we've actually had a sort of controlled substance tracking system since the 1930s, where it was a paper copy that was sent to the state. The state did then make it electronic in 1997, that it allowed just law enforcement to look at it. And then I think in 2009, they finally created sort of this client-facing web interface where physicians can register with the PDMP to access patient-specific records. So they can pull up the patient and they get what a patient activity report. And it varies state to state, but most PDMPs gather, the patient name, address, date of birth, identifying information for the prescriber and the dispensing pharmacies, the national drug code of the dispensed drug, quantity, number of refills, the date it was prescribed, the date it was dispensed, and then in California, they also collect the ICD diagnostic codes. So they have that information in the database as well.
So we're going to talk a lot about the questions around law enforcement access and licensing boards and other governmental entities. But can you talk a little bit about why, are there public health and patient care reasons for having these databases? Oh,
yeah, definitely. I mean, there are actually incredible tools to help physicians make appropriate prescribing decisions. And I think everybody can agree that the opioid epidemic is a real public health threat and something that just really needs to be addressed from not just the law enforcement side, but also from the provider side. I mean, they do need to work towards making appropriate prescribing decisions and then preventing abuse of prescription drugs and identifying potential drug shoppers. But beyond that, I mean, it's a great tool for physicians just in their making clinical decisions. I mean, they have to accurately diagnose the patients, but they also have to closely monitor their patients and what kind of prescription drug intake they're having, and that's, so that they can ensure that there is an effective and safe use of the prescription drug. So it is a great tool, a great clinical tool, and honestly, physicians and other healthcare professionals have really ramped up their use of the PDMP because it is so useful. And I think since 2014, there's been a 121% increase in the use of the PDMP by healthcare professionals.
In California, is access by healthcare professionals who are treating a patient mandatory when someone comes in, or is it optional? So last year we had a bill, SB 482, that creates a duty to consult. So that means that before there's any prescription that is written, the prescriber does have to consult cures. That has not been implemented yet, so there's some resource issues to make sure that the system can actually handle that kind of influx. And obviously there's some exceptions when the system is down, or we did fight to make sure that there were provisions in place so that people don't have there's not a barrier to access to prescription drugs when it's needed. Mm-hmm. So, but that's not in effect yet. The DOJ is going to certify that their system is ready, and then we have 6 months before it will be in effect. And do you know how long are prescription records held in this database? Is it everything
Forever.
that someone, so starting from the first time you visited a doctor and had a pharmacist prescribe, it's going to be in there forever?
So some states, like I think New York has a 5-year limit, so they only keep records for 5 years, but in California it's forever.
Okay. So let's turn to you, Ryan. So, when people talk about medical privacy issues at conferences like this, it's often kind of in the abstract, and we think about, the value of privacy, and we try to extrapolate the kinds of harms that could happen when there are inadequate prescriptions or protections for privacy. But it's relatively rare to hear from somebody who actually can tell from firsthand experience why privacy protections and protections against unjustified law enforcement access are so important. And you've lived through that, so we'd love to hear a little bit about your experience in Utah and what happened.
Okay. Again, my name's Ryan Pyle. I work for Salt Lake City Fire Department. We have a department of about 25 stations, 480 active firefighters. In 2013, it was discovered that there was some tampering with some of the narcotics that we carry as paramedics. This launched an investigation. department-wide. In about April of 2013, I was notified by a police agency that they'd like to speak to me about the narcotics that were tampered with. So I went to the station. It was very cordial at first. The officer asked me if I was aware of the narcotics. I said, yeah, I've heard about it. He asked if I had anything to do with it, knew of anyone that might be involved, and I stated no, and I wish I did. And at that point, things kind of changed. He said, well, the real reason you're here is I've looked at your prescription history and I don't feel it's appropriate. And I said, excuse me? He said, yeah. He said, I've accessed everyone in the department's records, and I'm looking at yours and I didn't feel it was appropriate. And at that point, things changed. He started reading me my rights, at which point I got up and I promptly left. I went out and I called my wife, who's here and is also a provider, and I said, hon, can you look at my prescription records and see what they're looking at? And she looked at me, she goes, I can't. You're not a patient of mine. At that point, I went to my doctor, and he pulled it, and he said, there's absolutely nothing here that's out of the ordinary. I'm aware of everything. So about 6 months went along, and I hadn't heard anything. And so after about the 6 months, I was formally charged, at which time I was put on leave from my department. And that was kind of a side note. The big thing here is my wife and I were, excuse me, very personal still, in the process of adopting 2 little boys. At that point, the adoption very much could have been, the boys could have been taken away from us. And our legal battle was about 18 months that we went through this. The news media was at our doorstep. I mean, it was big news when this happened. I was in the news weekly. Firefighter accused of prescription fraud. A lot of things went on. And again, we battled this for about 18 months. Every week there was the prosecutor said, oh, we'll give you this deal. It can be over. And I'm like, no, I can't do this. I have too much at stake. And I think the kicker of this was towards the end of it, he offered me one more deal. And he said, if you don't take this deal, I'll see to it that you go to prison. And I looked at him, I said, sir, I'm sorry, I can't do this. I've done nothing wrong. He said, sure you have. Law enforcement says they didn't agree with what you're being prescribed. And I apologized again. I said, I'm sorry. And he said, you will go to prison. 2 months later, the case was dropped. And somewhat, so our kids were safe. Everybody always asked, did you get to keep the boys? Which we did. But just that 18 months of not knowing, and a lot of people have no idea that law enforcement could access your records like that.
So in 2013, when this happened, the law in Utah allowed a law enforcement officer to directly log in to the state's PDMP, right, as long as they had an investigation number to tie it to?
That's all they needed was a number, an investigation number, just on a whim. And I will say Senate Bill 119 did pass in the state of Utah that now requires law enforcement to have a warrant to access the database. And don't quote me on this, but the number has dropped dramatically from their access. I believe it's about 92% that it has dropped since law has been passed.
Yeah. Well, I'm glad you mentioned that, Bill, and you kind of mentioned it in the passive voice. But as I understand it, your ordeal and the subsequent coverage in the media about the terrible injustice that you were subjected to after this dragnet search of your records on no real suspicion really motivated the legislature to act and to change the law from allowing police to just log in to requiring them to go to a judge, demonstrate probable cause, and get a warrant.
That is correct, yes.
Yeah.
Because of our case, and there were several other firefighters that were involved with this, and because of what we went through is the reason the law has been changed in Utah.
And in 2013, when this started, had there been a warrant requirement then, would any of this happen to you?
Not at all. Matter of fact, when the police officer was asked why he accessed the database, he said he was looking for suspects. I was not a suspect. I had not worked at the stations where the narcotics were missing. Something that I always look back on, all our narcotics are locked up in a safe. They could access who opened those safes. To me, that would have been a maybe reasonable suspicion to see who had maybe been in those safes, but he decided to access 480 people's medical records.
Without probable cause.
Because he could.
He had no reason to believe that any of those 480 people were suspects?
Not at all. He was creating a suspect list.
And you weren't the only one who ended up facing charges that were later dropped, right?
That is correct. Marlon Jones, and he said it was okay to use his name, assistant chief of the department. He was also same type of ordeal that I went through. For no reason, and his charges were ultimately dropped. But yeah, there were a few other people that were looked at that went through what I did.
Yeah, and as I recall from reading about and helping with your case, law enforcement actually went to one prosecutor initially who said, "There's not enough here. I'm not touching this," and then they had to go find another prosecutor who would take the case, right?
Originally, the
It was so
case
flimsy.
went through to the DA's office. They screened it, declined to prosecute, and for whatever reason, it went on to the AG's office. They found somebody up there that said, "Sure, we'll take a look at it."
Yeah. So Mark, why don't we talk to you and put this in a little bit of national perspective? So in Utah, the law as of a few years ago was any law enforcement agent can get a login password credential, go right into the database. Now there's a warrant requirement. But 49 states, as Lisa said, have these databases. Can you give us a lay of the land? What are the variation of protections? What's it look like across the country?
Well, first of all, across the country, to underscore a point that you talked about, Nate, there is very valid reason for the use of these prescription databases. They're very valid to help doctors stop people that really are abusing the system, breaking the law, and obtaining very dangerous opioid drugs. When I first heard about what happened to you, Ryan, I thought there was a mistake in the person that was telling me what was happening to you. I thought they just had the facts wrong. Because to underscore a key point, even when you were charged, it wasn't with what that police officer was originally investigating, the problem with some drugs. He found something entirely different, and you had a police officer with no medical training making a medical judgment about the appropriateness of your care and then charging you with a felony.
100%.
Along with a coworker of yours who was another firefighter. My assumption, Nate, was that, like many people that I tell on a regular basis this story to, that HIPAA protected our private medical histories. I thought that HIPAA protected something as sensitive as my drug histories, not just controlled substances, but also, as was mentioned, other very sensitive drug records. I thought HIPAA did that, and so did everybody that I told this story to. And I think that's the vast assumption in the general population. What we did was we decided to take a nationwide survey, and here in the room is also Angela Hill, who is a national investigative producer in my team. And together we just started calling all 50 states and really pinning them down in very meticulous detail on what are the rules in your state. And what we found is that 31 states in America currently allow warrantless searches of your private prescription records. 31 states. Warrantless searches without proving probable cause, without having any third party evaluate the law enforcement request to see information. There are different tiers of this. 15 of those 31 states will allow a law enforcement officer, just like what was previously going on in Utah, to sit down at their computer and log in from their own computer without having to go before a judge, without going before a grand jury, and simply tapping into the entire prescription database for everyone in their state. And in some cases, they're now interconnected into an interconnected system, and so they may be able to access beyond their state. So this started, of course, raising some very serious questions on our end, and we decided to contact some of these states. And I just want to read to you a couple of quotes that we got directly in writing from a couple of the states to really underscore the magnitude of this. In West Virginia, we found that police only have to promise that they have some kind of an investigation, and then they get full free-range access. The quote that we had from them was, "There, no case number or other certification is even required to access this database. Just their word, police word that everything's going to be fine, and they get right in." There are other states that do some smart things here. Minnesota, for instance, allows some access to these records, but they only allow, I think, 2 years worth, the most recent 2 years worth. So they can't just go and search and find out if 5 years ago, if you've taken some antidepressants, perhaps you've lost a wife, a loved one, a son or a daughter, and perhaps there was a period in time when you had to take something that might you might not want others to know about. In Minnesota, they put a limit on that. But yeah, I mean, we did find that this was the big surprise to us was despite HIPAA, which doesn't apply here, that 31 states are actively allowing law enforcement to tap in.
And did you get a sense of the volume of these requests across the country? You know, how much are these law enforcement requests happening?
It's remarkable. In one state alone, we found between 2014 and 2015 in Texas, 57,477 times the cops tapped in. That's a state that doesn't require a warrant. So this isn't 1 or 2 or 5 or 10 or 20 times, but this is routinely happening on a regular basis. And so similar, that's a large number. They're a large state. But of the states that do require some kind of a warrant, their numbers are far lower. And I think the interesting thing to me is in every one of those states that does have some tier of protection, whether it's a search warrant, whether it's a grand jury subpoena that's required, or some kind of third-party judicial review prior to allowing police officers to get in, there are plenty of police investigative procedures that are moving forward. The bad guys where the police do have probable cause to move forward, whether it's a doctor prescribing illegally or whether it's someone who is doctor shopping. When police have probable cause to believe that a crime has been committed, just like in other kinds of crimes, they're able to move forward, they're able to get access to the information. But for whatever reason, this is a loophole that is gaping wide and that remains open, and most people have no idea about it.
I'm always interested to look at that list of states with better protections, and it doesn't fall along sort of blue state, red state lines, right? It's some pretty conservative, quote unquote, states out there that have put very strong protections.
It's not a political issue. I think some of this came about, you have to look at the history of how these databases sprung up. And they sprung up, again, for good reason. They sprung up to allow the medical community to do an even better job of prescribing drugs appropriately. What then happened was once sort of the medical community created, and in most cases actually paid for these databases to be created, law enforcement entities decided they wanted to tap into the data. Now, there's nothing wrong with that. Of course, when they have reason and justification to tap in if they believe and can assert and prove that a crime has been committed. The issue that we found was that they're not having to make those assertions. And in fact, going one step further, what we found is that the DEA, for instance, at the federal level, nationwide, what they do is they issue what they call administrative subpoenas to access this information. Most states are honoring these administrative subpoenas, and what that means is the DEA officer investigating the case will essentially sit down at his desk, write up a piece of paper that says, I'd like to see these records, takes it before nobody. There's no judge that looks at it. There's no grand jury that looks at it, submits a subpoena, and then most states are honoring these administrative subpoenas, which for the most part are just very akin to what happened to Ryan here, where you have one officer with no review going forward, and where we have to trust and hope that they're not abusing their authority.
Yeah, and there's another interesting level of that issue, which is that even in the states that by state law require a warrant, the DEA is coming in and saying, we're the feds, we have the subpoena statute, we're going to preempt your state law, we get your records. And this is generated litigation that I've been involved in Oregon and Utah. Yeah. In Utah, shortly after the legislature changed the law to require a warrant, after learning about what happened to you, Ryan, the DEA came in and sent them a new subpoena, administrative subpoena, and said, too bad, your law applies to you, but not to us. Let's see the records.
Yeah, they're fighting back pretty hard.
Yeah, and the state of Utah is fighting back, which is great to see. And again, it's this is not a liberal conservative issue. It's protecting the prerogative of state law and the Fourth Amendment protections. So I want to talk a little bit more about legislative advocacy and legislative protections before talking more about the kind of legal framework. But Lisa, you're involved right now in some lobbying and advocacy efforts in California to try to get better protections around your state law. Can you talk about that?
Sure. So I've been working on this for several years, and it really started back in 2013. We realized that the cures system was really underfunded, and our doctors were complaining, saying, oh, I wanted to access it, or like my login is not working and I'm trying to get it fixed, and the phone number says that no one's going to call me back, and the email says that no one's going to write me back. And so we started contacting them, and they said, well, we have one guy running this whole system, so it's impossible for us to actually do any customer service. And so it kind of raised an issue, and we actually sponsored a bill in 2013, SB 809, which basically guaranteed about $1.5 million in funding for cures. It comes out of licensing fees from physicians and other prescribers. And so we got that passed, but in that process, we were kind of negotiating, and I started looking through the privacy statutes, and I'm like, okay, well, if this is going to be used more for a clinical tool, in California, the cure system was actually set up originally as a law enforcement tool. And physicians didn't actually have any access to it until about 2002, and the system has been around since the 30s. And so I was like, oh, so can the patients access their records? And they're like, oh, no, like patients can't access their records. In fact, like the physician can't even give the records to the patients because the patient is a third party, and you'd be violating the law if you were providing the patient's prescription record history to the patient. And we were like, but you said that you are complying with HIPAA, and HIPAA requires patient access. And they were like, oh, HIPAA doesn't apply to us. So I kind of started looking around and realized that our statute, which was written back in the 90s, is very broad. It allows for any disclosures to any governmental agencies for any administrative, civil, or civil or criminal proceeding, which pretty much is everything. And that's the only limitation in California currently. That's still the law, actually. So we went through different versions. Every year we have some sort of cures bill. Last year we had the duty to consult, and we tried to put privacy things in there, and that got cut out. The author did promise that he would support a privacy bill this year. So we had a more comprehensive piece at the beginning of the year. It got kind of whittled down, and now we have SB 641 that's moving through the legislature currently. And that would create a warrant requirement for law enforcement in California. I tried this last year because the DOJ actually has an internal policy that says that they will require a warrant for certain searches for law enforcement. But when I took their policy and put it into legislation, they were like, absolutely not. And so now we're back with the law enforcement warrant requirement, but we're getting a lot of pushback on that. So
what does law enforcement say? Like, what's their justification for needing access without a warrant?
Well, their whole argument, and this is something that comes up in the cases as well, is they say that patients don't have an expectation of privacy in their prescription records. Controlled substances, everybody knows, is regulated by the government, so everybody should know that the government has full access to all these records. And that it would impede investigations, in particular, really important investigations regarding the opioid epidemic.
So, Mark, did you hear similar things from law enforcement during your reporting? Were there compelling justifications they gave for why a warrant is too much?
Well, I think that their justification is they'd like unfettered access to be able to do what they want. And so, I have great relationships with law enforcement at the federal and at state levels across the country. I have great respect for what law enforcement does. But that their basic argument comes down to that opioids are a big deal right now, and without this tool, we're unable to conduct our jobs well to fight this epidemic. And I do remember having a conversation with one entity, and I said, well, let me just try to understand this. So you've had this warrantless tool for many years. I think it was in New Mexico we were having the conversation. And the folks and they said, and folks in Mexico, yes, we've allowed warrantless access in New Mexico. I said, so with warrantless access for your law enforcement officers there, can you just tell me, how is the numbers doing? I suppose that you've tamped down the opioid crisis. Oh no, we have one of the worst crises in America. And I said, well, how are you doing on overseeing your the law enforcement to make sure that what happened to Ryan is not happening to the citizens of New Mexico? And they said, well, we trust our law enforcement agencies there. So my colleague Angela and I went to the Albuquerque Police Department, and we asked the Albuquerque Police Department, how often, does your PD tap into the state database that you can access without a warrant? And they say, we never do that. We never do it. Well, we ended up uncovering records from the state, which confirmed that, and I wrote this down here, that they had 2 separate officers, in fact, that were tapping into the database, I think at least 35 times, showing that whatever oversight that was taking place had completely broken down, and that people really are in other states currently, or at least at the time that we posed the questions, tapping in without their bosses apparently knowing what they were doing. And that raised some very serious questions about what was really going on there.
Yeah, and I mean that seems to speak to the importance of front-end protections, when you can get in and for what reason, and also things like an audit trail, so that people can discover when that's happening and try to to stop the abuse, and both for patient access and for the press and oversight bodies.
If I could, I'd just like to add, I know in the state of Utah, the argument that law enforcement had is it makes their job too hard. That was their only comeback to why the law should be changed. They're like, well, it makes my job too hard.
Right, and it's ironic. Lisa and I were talking before the panel, and you made a nice analogy to if law enforcement suspects somebody of buying illicit drugs on the street, right, and they want to go search their sock drawer or their medicine cabinet, they're going to have to go get a warrant. But somehow people who are engaging in the allegedly same activity just through a physician now are open to totally warrantless scrutiny by law enforcement.
Yeah, and I think, for us, for physicians, I mean, that piece of it is really important, because they feel very strongly about patient confidentiality and protecting their patients' confidentiality. It's really the cornerstone of providing quality care. If the patients don't have trust in their providers that they can disclose very sensitive information, they won't be able to get the full care that they're probably going to need. And you don't want people withholding information because they think that the government's going to be looking at all of this information. So it's really fundamental to sort of the practice of medicine and the patient-physician relationship and being able to provide quality care. And it kind of breaks down when suddenly somebody's calling you and saying, hey, I know what you've been prescribed, and you're like, where did you get that?
Absolutely.
Yeah. Lisa, can you talk a little bit about the litigation that you're involved in California around what protections there are for physicians against access to these records to look at what they've been prescribing?
Sure. So in California, physicians actually have no access to see their own prescription records. So they can't look and see what has been prescribed under their DEA license, but law enforcement does. And then we have a couple cases in California, and obviously we were involved as amicus in your case in Oregon as well. But we have a case right now that's pending before the California Supreme Court, and it has to do with a physician. He had seen this patient for a non-related issue. He did not even prescribe the patient anything. It was a one-time patient. She filed a complaint against the medical board, not a prescribing issue, at which point the Medical Board of California opened up an investigation and searched 3 to 5 years worth of prescription records and cures of all of his patients. So they went through every single one of his patients, like thousands of patients. They subsequently picked about 5 and opened a more in-depth investigation on those 5 and subpoenaed medical records based on the information that they got in cures. And ultimately, the physician was put on probation, but not for overprescribing, really. It was just on record keeping, he had not done the proper record keeping. But he was appalled that they went through all of his patient records, and so he appealed it to the Court of Appeal in California, and we ended up getting like a horrible decision from the court, which pretty much said that patients don't have any protected privacy interest, despite the fact that California has actually a constitutional right to privacy. Unlike the U.S. Constitution, it's like there is a right to privacy in California. And the state basically argued that patients don't have a right to privacy in their prescription records, and so and even if they did, the public health options, public health interests of the state in regulating physicians and dealing with the opioid crisis outweighed any privacy interests, any diminished privacy interests that the patient might have in their prescription records. So that case was heard before the Supreme Court earlier this month, so we should have a decision in the next 2 months or so. So we'll see.
I was just going to weigh in because I remember that there was sort of a seminal moment for me when I was understanding the legal differences here on this subject. One of the great things that has already been decided years ago in our country is that there is, despite our great faith in the great institution of law enforcement, that there's good reason to not allow it to have unchecked authority. And that was going back to the days of the FBI when they had no real congressional oversight. And J. Edgar Hoover was able to lead investigations that were extraordinarily controversial and violated many folks' civil rights. And so then they had oversight. And so while we, of course, want to and need these institutions to succeed at their jobs, they do protect us. There is reason to have everyone checked in our democracy as we've sort of made those decisions. And so there's the final point someone made to me once that really helped me understand the differences here. On a civil level or from a regulatory purpose, if there is a regulatory board that is looking at how are doctors performing for civil or administrative purposes or regulatory purposes, that is one thing. But when a law enforcement entity becomes involved in an investigation, they have the ability to take life and liberty away. And so that is the reason why my understanding is that the courts have said because of that extra power that they also have an extra responsibility to assert probable cause before using that extra authority. Great power. With great power comes great responsibility. And so that was a point that helped me understand, okay, this is probably a worthwhile story to continue to pursue.
Yeah, I think that's such important framing. And there are now more than several cases pending around the country looking at this issue of how the Fourth Amendment to the U.S. Constitution will regulate law enforcement access to these records. There's a case that you brought, Ryan, to try to address what happened to you and set a better standard in the law. Coming out of Utah, there's another case out of Utah that the ACLU intervened in against the DEA to try to get a judge to explain that the Fourth Amendment requires a warrant for these records. And then a similar case out of Oregon that the California Medical Association wrote a brief in that the ACLU is litigating alongside the state of Oregon, asking the same question. So hopefully we can rely on the judicial institutions to start to set the parameters in places where Congress or legislatures haven't acted yet.
And I also just want to add, it's listening to the panels yesterday too. It's such an interesting time for the Fourth Amendment, just because the technology. I mean, the cures has been around since, as I said, the 30s, but it was a paper record, and so there was some guy in a file cabinet like searching through the paper. But now, it's a computerized database, and it can be, attached to different other databases and really aggregated in the data. And so I think, the Supreme Court has seen those cases in the last several years with U.S. v. Jones, which is the warrantless use of the GPS tracking device, saying that was a reasonable violation of privacy. And I think they quote Brandeis and Olmstead in that opinion. And then we had Riley versus California, which was the warrantless search of the digital information on your smartphone. And in both those cases, there's a lot of great language from the court just talking about how there's a shift. So our our sort of understanding of what privacy is and what constitutes an intrusion is shifting a little bit because of the technology and sort of the power of technology to really aggregate data and have a lot of information about you. And to the extent that I totally respect law enforcement too, and I have no qualms about going after doctors who are dealing drugs out of the back of their office. I mean, those people are criminals. But like, I also feel like you can't just gather all the technology and then try to apply the outdated sort of rules on something that is not really the same. So.
Yeah. So we have a few minutes left, so why don't we take some questions? Let's start with you.
Thank you. The ostensible purpose of these PDMPs is to try to mitigate the inappropriate use of controlled substances, presumably. Are there any examples of states that are using these appropriately for that objective and succeeding?
To the extent that I could answer that, I'll show you one thing that I've got. We pulled something up here.
So if you just click on the Internet Explorer icon there.
Got it. Let's see here. So this was we created, I give you a tool, you can just play with this. If you Google Scripps and SCRIPPS and prescriptions, you'll find this story popping up on one of our many websites across the country. But what we've done is we've created a bit of a tool for you to at least try to get part of an answer to that, and you can sort of see how states are using the database. How often in Ohio they accessed the database 43,000 times, I guess, in a 3-year period. And then we also ask, do the states regularly audit such law enforcement searches? In Ohio, the answer is no. In many states, I think in most states, the answer is usually going to be no. Some states you'll find the answer will be yes, no. Florida does do some audits apparently, so their numbers are a little bit lower. But you can get a sense of how they're doing by playing on our website using a tool that we created. And there's one other aspect I would just show if you want to get a nationwide picture of this. We put together a chart that will allow you to see how things are going in your state, if they require some kind of judicial oversight or not. And if you scroll over the states that are here, you can, if I do a little bit better job here, you can just, we've provided some other information for you. Number of times law enforcement accessed the records in these different years, and the kinds of scheduled drugs that they track in their database. And also, in this case in Indiana, you can see that law enforcement only needs to present a case number and can have direct access. This does change from state to state, but this took us a long time to put together. I'd encourage you to play around with it.
So it's not clear how that data might correlate with some measure of effectiveness of dealing with the issue of opioids, or some measure of the extent of the problem in the state. It would be
I can
interesting.
answer a little bit specific to California.
Great.
So part of SB 809 and the funding that happened in 2013 required physicians to register for cures. So now it's required that you register so that you can access cures. It's not currently required to consult it before you prescribe, but it does give everybody access at this point. And as a result, I mean, physicians, as I said before, I mean, there's a huge increase since 2014 of people using healthcare providers using the PDMP, and during that same period of time, the number of opioid prescriptions has decreased by more than 43 million. It's a 17% decrease nationally in the number of opioid prescriptions that are being written by healthcare providers.
I want to make a comment because I don't think we necessarily have enough time for it, and it's not a fair question to spring on you guys here. But my comment is that people the experts on the panel are touched on something that I think is very dangerous, and that is compelled disclosure by physicians of how they're interacting with their patients. And when we take it out of the opioid context to, for instance, abortions or infectious diseases, where we have a range of public health concerns, which everybody on the panel seems to say, oh boy, you know, the physicians want this, and society wants this for public health. We're creeping into a situation where you're focusing so much on this warrantless access for law enforcement reasons, while inadvertently promoting a loss of autonomy on the part of the individual. Because as Lisa said to begin with, you're putting diagnostic codes in here. Mm-hmm. You're putting things that don't rise anywhere close to Bill's question about effectiveness. This is, I think, the issue that ACLU and California, states like California, I believe, need to start looking at, because we are digitizing so much stuff.
Yep.
And the Fourth Amendment issue that you just raised. And so focusing this on law enforcement is not necessarily doing overall a disservice. In other words, even if Bill's point is, yeah, there was some goodness, that the risk of harm is immense on the public health side. And we only have to look at Pakistan vaccination, for example, to see what happens when people take law enforcement and cross it into the public health domain.
Yeah, it's a great point, and Lisa talked a little bit about the kind of disincentive effect, right? Of when people think that their medical records are being surveilled, they may be less likely to seek medical care, and that certainly can be true of law enforcement access, but it also can be true just of knowing that your records are ending up in some centralized state database, if there aren't adequate protections, or even if there are some protections. So it's a very good point.
And from the CMA point of view, I mean, right now I'm talking about the bill as it is today, which is law enforcement access. But originally, when we put the bill in print, it had all sorts of protections, including notifying patients to make sure that they know that their information is going to be in there, and then putting a lot of restrictions on all sorts of other government agencies as well. Really, I mean, I think our goal is to have the prescription records be treated just like medical records. That's kind of where our goal is.
That's not so good, because our medical records can all be sold. All the prescriptions from every pharmacy are being sold. I mean, HIPAA actually doesn't protect our records. It enables the data holders to sell the information. And we anyway. So sorry, we have a long ways to go, but you all are fighting the good fight, and the broader question that Adrian raised, I think, is really, really important. And I think Bill did a great job of pointing out, we're measuring something. Are we measuring something that effectively helps the problem? And the answer is not necessarily so. Can you ask a real quick question? Because then we all have to walk over to a wonderful lunch and another discussion. I think this was a terrific panel. Can you ask something quickly?
Yes, it's a very quick question.
Okay, thank you.
I'm the CMIO at my hospital, and it fell on me to facilitate, to come up with a way for physicians, both in the hospital and the affiliated outpatient practices, to be able to check the PDMP in Massachusetts, which is required for every single opioid prescription. It was lovely work. I'll summarize it that way. But my question is that when I would log on to the PMP, it started off with I only had access to Massachusetts, which is where I practice, and then all of a sudden, very, very quickly, Connecticut, Rhode Island, West Virginia, states across the country all of a sudden start showing up where I can check the box and look at prescriptions basically across the country. I'm wondering about, with your concerns about law enforcement, is there any restriction from them checking another state's PDMP?
Certainly not from the DEA level. I mean, they really are pursuing this, even when, to the point that a state legislature has acted on the will of the people and instituted a warrant requirement. They are continuing to fight to try to get warrantless access. I think that it is a fact that many people like you that are operating in a state that is on, I believe, what's called the interconnected system.
It's the PMP Interconnect.
PMP Interconnect.
Massachusetts just joined.
So then it's not nationwide yet, but I think it's more than half the nation.
It's 40 states that allows this sharing of data across state lines.
You know, and one protection that could be important, and some states have this in state law, Oregon's one of them, is to ensure that the state is not allowed to share with any other state that doesn't have equivalent privacy and security protections. And so, you know, that is helpful for the states that have a warrant requirement and audit trails, et cetera. Not so helpful for states that are, you know, on the bottom of the barrel. But I think that can be a mechanism.
There is a mechanism in place in PMP Interconnect where each of the states have different laws. And so when you try to connect, if you don't, you know, if you're law enforcement and you try to connect into a state that requires a warrant, it will require you to get a warrant.
Great questions. Great questions. Yeah, the only thing that I would add before we close as a practitioner is, in my experience, all of this tracking leads the physicians to not want to prescribe, and has actually made it much more difficult to get medications when they're warranted. And many people do not want to take medications that are tracked, and the physicians don't want to be tracked either. And so it's a complicated problem. And I have to also say, thanks to working with Nate, I discovered that what was it? A third of the country has a diagnosis of chronic pain, something like that. And, you know, we have opioids exploding, and I just have to tell you, because I've been around forever and I'm a dinosaur, but we wiped out our mental health system in the 1980s. There's really no treatment. We used to get mental health and addiction treatment, got 8 to 10% of the healthcare dollar. After the 80s, 1 to 2%. So there's not a lot of treatment available, and people who are depressed, anxious, in pain, you know, we wiped this out, and I think that's a piece of why there's an opioid crisis, and Congress is not replacing that. So anyway, my 2 cents. Thank you for letting me speak, and thank you so much, Nate, for putting together this terrific panel. Ryan, oh my God, thank you for being such a hero.
Thank you for having me. It's very, very important to me.
Well, and this is very important to, you know, to have your story out there and for people to talk about how they're harmed. We thank you very much for that. Lisa, terrific, great to know. And your slides about the beautiful work you put together for people to be able to check in their own states is wonderful. Thank you for that resource. And so thank you for this wonderful panel.
Thanks.